Welcome everyone to this webinar on detention, on alternatives to detention in the EU Pact on migration and asylum legislative proposals. I'm Karolina Babicka from the International Commission of Jurists. And this webinar is a second one in the series that the ICJ organizes as part of our CADRE project, which is a project of a group of national and international partners aiming at the promotion of alternatives to detention of children in the immigration context, and ultimately aiming at bringing the national reality in line with international human rights law in this area, under which immigration detention of children is prohibited. The EU Asylum Acquis is undergoing yet another update, and the legislative process is ongoing. So the Commission has published a set of new legislative proposals that are currently being discussed in the European Parliament and in the Council. And these proposals may likely result in more detention and systematic detention at the border without fully exempting children. So today we would like to look at these proposals again and hear more especially about the proposals for alternatives to detention in the legislative process. And we will hear from an insider from the European Parliament about the negotiations. We will also be looking at some concrete examples of how vulnerable people and especially children are treated when staying at the border, both in Greece and Italy, whether detained or not. And what is the latest case law, and what are also the lessons learned from these situations. We will also hear about the discussions that are ongoing in the NGO sector, whether at all alternatives to detention are possible at the border, if the starting point is still children should never be detained in the immigration context. And finally, we will have hopefully a couple of minutes for the discussion, but we also encourage you already throughout the webinar to just come in the discussion in the chats, because there's a lot of experts that are here with us today. So it would be good to have your questions, have your comments throughout. So I will just start with setting a little bit the scene by looking at what the Commission has proposed in the EU Pact in September 2020. It has been a proposal of a number of legislative files, updating, changing, or merging the previous EU Asylum Acquis. And I'll focus especially on the screening regulation and revised asylum procedures regulation. In these two files, the Commission proposed establishing a mandatory pre-entry phase and new border procedures. Within the initial screening procedure, they propose for up to 5 and maximum 10 days that people would not be authorized to enter the territory of a member state, so the so-called fiction of non-entry. And according to the proposal, in individual cases, it may include detention. Under the asylum procedures regulation, people are likely to be detained systematically for even longer period of time. A border procedure would apply to asylum seekers who are either unlikely to be granted asylum, whose claim is fraudulent or abusive, or who are considered a security risk. Such claims must be examined within 12 weeks, and applicants subject to the border procedure shall not be authorized to enter the territory of the member states while the claim is being examined. Unaccompanied children and families with children below the age of 12 should be exempted from these border procedures. So overall, the proposals say that people may be detained in these situations, and potential detention would be dealt with according to national law. So in our point of view, it would inevitably result in prolonged immigration detention as a practice at the border, without it being actually regulated in EU law. So the risks related to these proposals that we've identified come to the right to liberty and security, especially detention of children, at least those above the age of 12. Lack of judicial review of the detention order, the question about detention conditions not being regulated, and also the jurisdiction of states being put in question through this fiction of non-entry. So there is a high risk of systematic detention at the border in breach of international human rights and refugee law, while according to international law, detention must be only used as a last resort, applicable only in well-defined situation and be based on a case-by-case assessment of the situation of every person. So the ICJ published a while ago a legal briefing analyzing these points and suggesting some recommendations. First, that each deprivation of liberty must be expressly required to meet the conditions of lawfulness, necessity, and proportionality. It should be specified that detention may be only used as last resort, only where less coercive measures cannot be applied. It should be specified that detention should be only for the shortest period of time. Detention must be subject to procedural guarantees. Judicial review of the detention must be available. And it should be specified that detention must be in adequate facilities in line with international human rights standards. Finally, children and people in need of special procedural guarantees or special reception needs must not be detained, and so we suggest they should all be, they would all be exempted from these procedures. So for the start, that's an overview of the proposals and some of the ICJ concerns therein. And let me now probably just pass the floor to the next speaker, who has an insight in the process within one of the EU institutions, the European Parliament, and who will then also tell us a bit more about the current proposals and the counter proposals in this area and where the negotiations are at the moment. So let me invite Maria Giovanna Manieri, who is the team leader of Rights and Democracy in the Greens EFA group in the European Parliament. Thank you very much for being here, Maria Giovanna, and please, the floor is yours.
Thank you, Carolina, and thank you all for being here. You are so numerous. It's a great pleasure to be here and be able to discuss with you today such a crucial issue as the ongoing discussions, in particular on the Asylum Procedures Regulation and the border procedures, and of course the implications that this has for applicants, deprivation of liberty, restriction of the freedom of movement, and of course impact on their overall right to seek asylum and possibility to implement the safeguards. As Carolina has said, I work in the European Parliament for the Greens EFA group, and I have been following the ongoing negotiations on the new Pact on Migration and Asylum, but also the previous failed negotiations on the Common European Asylum System. And I have been working for a long while on migration and asylum. So it's with this sort of insight that I want to come today to you and talk a little bit about what's going on in the European Parliament. I've already mentioned the two notions, of deprivation of liberty and restriction on freedom of movement. Please keep this in mind because in my mind, throughout the presentation today, this would be our guiding principle when discussing and looking into the current state of play on the negotiations on the Asylum Procedures Regulation. I will focus on the Asylum Procedures Regulation because I've been asked to do so, but also because this is probably the one proposal where the highest risks in not implementing or including the correct safeguards are visible and would be visible. So please keep in mind the two notions of deprivation of liberty and restriction of freedom of movement, because also this is something that is a bit fictional, if you want, but created in the Asylum Procedures Regulation proposal. I have structured my intervention into two parts. The first part will be looking into more abstract, if you want, but necessary consideration around deprivation of liberty at the borders in the Asylum Procedures Regulation. And the second part of the presentation is probably what you will be looking forward to hear, and is going to look more specifically on some points that are currently under discussion as part of the negotiations that are taking place within the European Parliament on the Asylum Procedures Regulation. I'll be focusing on the negotiations within the European Parliament because I don't sit in the council, but also because, as you know, council is also still negotiating quite slowly on these issues. So let me start with a number of general but necessary considerations on the right to liberty and border procedures. So when it comes to compliance with personal liberty, perhaps the most striking point and characteristic of the EU Pact is this implicit but conscious blurring of the lines between detention, stricto sensu, so detention, for example, in a detention center, and restrictions on freedom of movement of other sort. That is to say, for example, other containment practices or restriction of freedom of movement to a specific geographical area, which is something that we see, for example, in the Reception Conditions Directive proposal, as you may remember. Now, the essential question that is raised by these practices is to what extent our current safeguard framework, including the alternatives to detention, would be capable of addressing the resulting challenges. As you know, screening and border procedures are both characterized by the refusal of entry, also as Carolina told us, and hence this so-called fiction of non-entry. This particular construction has an inevitable impact, as you know, because you're practitioners, on the liberty of applicants who apply for asylum at the border or in a transit zone. And of course, in these procedures, entry is refused precisely in order to prevent free movement within the territory of the member states, but equally, obviously, this creates a tension with the applicant's right to remain under EU law and the protection from return until the existence of risk of refoulement is assessed, and of course the right to asylum under Article 18 of the Charter. So you see the tension, and it is important also to keep in mind and realize that the situations of de facto detention under border procedures and the external borders of the EU will most likely continue to be the norm in accordance with the current Commission proposals. And also, of course, it is important for you to keep in mind that majorities in the current European Parliament mean that flipping this logic will be very hard, if not impossible. We simply do not have a sufficiently progressive majority to refuse completely this part of the Commission proposal. So what we have to do, and what we currently are trying to do very hard, even though it's not easy, is to focus on ensuring that all the safeguards that Carolina has mentioned in their introductory remarks are going to be applied, including at the external borders of the EU, including on border procedures. And I particularly, I really want to focus particularly on this because this is not granted. Yeah, this is really an element of tension in the current negotiations. We have to continue battling for detention to remain a measure of last resort, also in practice, which means through the application of alternatives to detention, and for the habeas corpus guarantees to be in place. So giving detainees the right to have the lawfulness of the detention speedily reviewed by a court, and also to have the detention lifted if it is unlawful. As I said, we're really battling to maintain these safeguards. It's a rather frustrating exercise, as you can imagine, because one would only be happy to assume that these fundamental safeguards should already be sufficiently enshrined in our legal framework, and being in a very politicized and complex negotiation such as this is not always very rewarding. But allow me now to come into the part that may be more interesting for you, and that is the second part of my presentation, and that would be trying to give you a short overview of the more specific challenges that we're now facing as part of the negotiations. And in particular on provisions of detention at the external borders of the EU and alternatives to detention. As you know, on the basis of the screening procedure, third country nationals would be referred to different sorts of procedures. Yeah, so we have the asylum, the refusal of entry, or the return procedure. When persons are channeled into the asylum procedure, their asylum applications will be either addressed in a normal procedure or in a border procedure. So we're here in the border procedure. And as we mentioned earlier, and as Carolina has said, the main and defining characteristic of a border procedure is that the applicant is not yet authorized to enter the member state's territory. There is this fiction of non-entry that is created. And in this sense, if you think about it, the proposed border procedure is actually really similar to the existing Article 43 of the Asylum Procedures Directive. And this is why one of the very first actions that the European Parliament has undertaken, even before the European Commission had proposed the new pact on migration and asylum, was to start and finalize an implementation report, specifically looking at the implementation of Article 43 of the Asylum Procedures Directive. One of the criticisms that the Parliament had voiced to the European Commission was the fact that implementation reports on the existing status quo, so the existing directives, were not up to speed and were not really presented in time. But we found that particularly looking at the implementation of border procedures and Article 43 would have been useful and interesting for the discussion. Let me look into a couple of points that this report has highlighted, and I would like to invite you also to read this if you want. I can share the link with you. So the report has highlighted a number of important points that are still important for the discussions today on the Asylum Procedures Regulation. First of all, it may seem obvious to you, but the report actually says that applicants subject to border procedures are likely to be placed in detention during the examination of their asylum applications. This wasn't at all obvious when we started discussing. We really had to negotiate to actually say this clearly as a first sentence. Then more specifically on alternatives to detention, the report already regretted that despite the Reception Conditions Directive provisions stipulate that detention must remain a measure of last resort, hardly any alternatives to detention were applied or are applied in border procedures. So we encourage member states to take the necessary measures to ensure that alternatives to detention are actually available, but we already recognize that in practice this doesn't work. And we also, on the issue of detention of children, the report recalled that the best interest of the child should be a primary consideration, but also reiterated the position of the European Parliament on the Asylum Procedures Regulation, the previous one, that children should never be detained as part of border procedures, and that the border procedure may only be applied to children where there is an alternative available to their detention. Why am I saying this? Because this was the position of the European Parliament in the previous legislative term. Unfortunately, we never got to vote on this position, which doesn't really make a difference, unfortunately, today, because as you know, the Commission has come forward with an amended proposal, which means that negotiations had to start anew. But today we are in a very different position. So we have lived a major setback and we have to come back to this, but it's not easy in the current state of the negotiations to come back to even this position, clearly stating that all children should be exempted from border procedures and detention. So I also keep this in mind. Finally, so we come to the current Asylum Procedures Regulation proposal, and in particular, the article we should focus on today is Article 41(6). In the amended proposal for an asylum procedures regulation, because this is the one that makes explicit that applicants subject to the asylum border procedure shall not be authorized to enter the member state's territory, and hence this is when detention de facto applies. I think Carolina mentioned it quickly, but keep an eye also that just as with regard to the screening procedure, also in the border procedure, it is not in the IPR, it is not really unequivocally clear how the refusal of entry of applicants relates to the right to personal liberty. For example, if you look at recital 40F in the amended proposal of the Asylum Procedures Regulation, you read that the border procedure for the examination of an application for international protection can be applied without recourse to detention. So it is not a mandatory detention. However, the recital then goes on and says member states should be able to apply the grounds for detention during the border procedure in accordance with the Reception Conditions Directive. So we are left in a situation where it is clear that for the screening phase, the regulation on detention will be left to national law. For the border procedure in APR, it will be regulated by EU law. Yeah, and we look also then at the Reception Conditions Directive, and in particular, if you want to look at that, it would be Article 8.1d, which provides that in order the detention is possible in order to decide in the context of a border procedure on the applicant right to enter territory. So this is our legal basis. While negotiating now Article 41 of the Asylum Procedure Regulation, as I said, negotiations are not easy, and the safeguards are the crucial focus. We await a round of negotiations, another round of negotiations very soon, this Friday. And I'm saying this today because it's going to be a major round of negotiations, because the point that we will be discussing on Friday is whether border procedures will be mandatory or optional. It's not a detail. Okay, you may say, well, the status quo is that they're not mandatory, so it's not really a step forward. But if, of course, compared to the Commission proposal, it would be really a step forward to ensure that they are not mandatory. So this will be the focus of the discussions on Friday. But of course, there's a number of other issues that still require a lot of attention, and I want to raise your attention to maybe 3 of them, and then I conclude, I promise. So look at Article 41. We currently have Article 41.6 that provides that applicants subject to the border procedure shall not be authorized to enter the member state's territory. And the European Parliament is now adding an amendment specifying that in accordance with the Reception Conditions Directive, a member state should not decide to hold an applicant in detention until it has individually assessed that applicant's case and effectively considered alternatives to detention or less coercive measures. This is the compromise that is currently on the table, and as you can see, the language is somewhat vague, so some work is still necessary in order to ensure that this can become a safeguard, because vague language doesn't necessarily ensure safeguards. Yeah, the Parliament is also introducing an amendment which would include another paragraph after 6, so a new 6b, which I also find a rather good example of how compromise language sometimes can read. So bear with me 1 second. Compromise says the responsible authorities shall explore alternatives to detention in border procedures, in particular for specific groups such as minors, families, and applicants with specific vulnerabilities. So this word, the responsible authorities shall explore alternatives to detention, is like the utmost example of how compromises can be vague at times and really not guarantee any specific safeguard. I recognize that we still have a lot of work to do there towards clearer language as well. The compromise also adds that where possible, children should be accommodated in non-custodial community-based placements while their immigration status is being resolved. So you see the step back that I mentioned earlier. We no longer say as European Parliament, at least for now, children should not be detained. We say minors should be accommodated in non-custodial community-based placements. And I struggle to understand exactly what this will mean. So we're not happy yet with this state of the art. But of course, I just wanted to give you an idea of what the discussion looks like at the moment. I think we also, in a self-critical way, recognize the fact that we are not at all being practical on what alternatives to detention are. I do not think this is a discussion that the European Parliament will be able to solve. And that's why there is also another proposal to introduce an amendment that would mandate the European Union Agency for Asylum within 6 months after the date of entry into force of the Asylum Procedures Regulation to develop guidelines on different practices as regards alternatives to detention that could be used in the context of a border procedure. It's a way of saying, we need to know more, we don't know enough, but I think it's also a way of saying we're not entirely sure that we can legislate on this at the moment. The Parliament is very divided, and I conclude with this observation. It is a difficult negotiation. As you see, it is very politicized. You can see how politicized it is looking at the choice of words that is made. And yes, unfortunately, we will really have to continue working, and it won't be finished very soon, I must admit. I'm happy to also answer questions later, should you have any. Thanks so much.
Thank you very much, Maria Giovanna. Good morning, everybody. So I'm Roisin Pillay from International Commission of Jurists, and I'm taking over for the moderation from Carolina for the rest of the event. Thank you so much for setting out the very difficult negotiations that are going on. And so we've heard now from both Carolina and Maria of the issues that there are at an EU level. What we want to do with the next presentations is look at what the issues are at the borders in the member states, focusing on, in particular, on Greece and Italy, so that we look at the particular context in which these EU standards and EU regulations are implemented and will be implemented in terms of the new package. And the difficulties that presents, what the procedures are at the borders, how or to what extent those can protect children, and the risks of detention and the questions around alternatives to detention. So before I hand over to the next presenter, just to say that we are going to have some time for questions at the end, not a great deal of time. And because we're short of time, I'd like to ask those of you with questions to please put them in the chat so that then we can ask them. If you would write the questions in the chat, and then I will try to group them together and put them to any or all of the speakers. So now I would like to hand over to our next speaker. We're very pleased to have Alexandros Constantinou, who is a senior lawyer and the head of legal research at the Greek Council for Refugees, and who of course has been cooperating with us closely on this work on alternatives to detention for children in migration. And so he will speak about the situation in Greece regarding conditions for vulnerable people, including migrant children at the Greek border. Thanks, Alexandros.
Okay, thank you very much, Roisin, and thank you very much for the invitation. I'd like to share a presentation, so let me try. Okay. I think that now you can see the presentation, is that correct?
Yes, we see it. Thanks.
Okay, super. So my colleague, Mrs. Tsovili, that she will speak right after me, she will present the National Emergency Response Mechanism for Unaccompanied Minors in Greece, which is it has been a new mechanism established the previous year, and has been a very significant step in order the detention of unaccompanied children to be stopped, detention that it used to occur while unaccompanied minor children, they were waiting to be placed in special accommodation facilities. So I will not really speak on this aspect of measures with regards the protection of children, but I have been asked to speak about the conditions of newly arrived persons on the border, including vulnerable groups and migrant children. I will try to be really brief, and I will say that potentially most of you are already aware of the situation that used to occur on the Greek borders, particularly on the Greek islands, the previous year. Situation that has to do with, really substandard and inappropriate reception conditions of newly arrived persons. The situation has been changed the recent years. Actually, that had to do with a significant decrease of persons that arrived on the Greek reception facilities at the borders during the previous years. However, we do have new protection issues that they arise, and they are really, to my understanding, related with the ongoing discussion on the pact and the ongoing discussion on the treatment of newly arrived persons on the European border. So I would say that there's a number of measures that are highly problematic under the auspice of in the view of how do we apply detention measures on the border. So first of all, we do have quarantine measures that they are applying upon arrival, and people that they are under these measures, actually they are kept in de facto detention, and in a number of cases they don't have access to their mobile phones, they don't have access to a lawyer, they don't have access to UNHCR, so they are deprived of any meaningful communication while this period, which can exceed to something like a week. And then after this period that they remain in quarantine, they do have they will undergo all the procedures, including the asylum procedure, potentially without having the adequate access to information. And then we do have an up to 25 days restriction of liberty within the premises of the so-called close control access facilities, which is the reception centers on the Greek islands, and it's also the reception center in Evros region. To our view, but I think that it's something that it's quite obvious. Restriction of liberty within the premises of a reception facility, it is a de facto detention measure. This is something that, according to the Greek law, is provided for a period of up to 25 days, and it is applied to anyone. So this is also a de facto detention measure, and maybe it seems like the proposal of the prescriptive regulation for a period of initial detention for identification purposes, and then we do have detention measures that they do apply in the new close control access facilities on the Greek islands, and in particular on the island of Samos. And there we do have a policy of prohibiting persons to exit the facility without any written decision in cases that the asylum seeker's card is not valid, which is the case of people who have received a negative decision. However, it's also the case of people who have not still managed to register their asylum application. Just to give you, I just want to speak a bit about the new close control access facilities on the Greek islands. These are 100% EU funded centers. They have been highly criticized due to their prison-like environment. And this is the new type of reception facilities that they will be present on the Greek islands, on the European borders for newly arrived persons. They are facilities that they have very high security measures are applied to these facilities, and we are highly concerned of the status and of the regime of stay of persons who will be accommodated to these facilities. As I said before, we already have a number of practices applied that they amount to de facto detention, and this is in particular the restriction of liberty within the premises of some centers for a period up to 25 days upon arrival. And it's also the practice of prohibiting exit to persons who do not have a valid asylum seeker's card. Just to complete the image of the conditions that people they are facing over the border, we should add that the majority of newly arrived people, they do not have effectively access to an in-merit examination of their asylum application. The majority of persons arriving in 2021 in Greece, something like the 60% of people that they arrived there, they were they were belonging to those nationalities for whom Turkey has been designated as a safe third country. So they were subject to a safe third country examination and not to an in-merits examination. And this includes persons from Syria, Afghanistan, Somalia, Bangladesh, and Pakistan. And that said, as we discussed for alternatives to detentions, I think that we should make a question as to whether it is actually pertinent to discuss about alternatives to detention, given that at least what is the Greek case, that removal is not feasible. We do know that that readmissions to Turkey have been halted already since March 2020, and it's not expected that they will resume, as Turkey now is asking the Greek authorities to, as the fact that the Greek authorities have, without a previous bilateral discussion, designated Turkey as a safer country for 5 nationalities, has created extra problems in the implementation of the readmissions to Turkey, of the readmission procedure to Turkey. So I think that since removal is not feasible, it's a bit problematic to discuss, even to discuss about alternatives to detention, given that removal is not feasible. I think that what we should discuss is how we will provide effective access to an in-marriage asylum procedure to persons and decent reception conditions. The last thing that I want to add in order to complete the image of the conditions that people face on the Greek borders has to do with something that it's quite well documented at the time being. It has to do with what the special rapporteur for migrants of the United Nations has recently said as a de facto general policy. It has to do with pushback practice on the Greek border, because what I said before, and the risk of detention and the risk of not being have access to an in-marriage examination, it concerns to persons that they have managed to arrive on the European territory. But I think that it's highly problematic that we have a significant number of testimonies of persons saying that they did not manage to have effective access on the territory due to pushback operations on the Greek-Turkish borders. This is what recently has been highlighted by the UN Special Rapporteur on the Human Rights of Migrants. There has been a report of the rapporteur and a special reference to the Greek, to the case of Greek, according to the special rapporteur. Pushbacks at land and sea borders have become a de facto general policy in Greece, and this has also been the case of the very recent concluding observations of the Committee on the Rights of Children of the United Nations, that they have identified a number of issues of concerns with regard to children, migrant children in Greece, and that include the reports of forced returns, of pushbacks, immigration detention for identification purposes, issues that have to do with the reception conditions, and lastly, an issue that has to do with double standards applied for children belonging to different nationalities. I think that these are issues that they should be further discussed. So thank you very much. I just tried to make a brief presentation, but I do remain here for any discussion or further questions. So thanks a lot.
Thank you very much, Alexandros, for that very interesting presentation. Just to say, I'm not sure we all saw the slides moving as you went through. So, I mean, maybe if you can circulate the PowerPoint presentation, this would be interesting to the participants. Thanks very much. And again, to all the participants, please do think of any questions you have for Alexandros or the other speakers and put them in the chat, or indeed comments. and responses to the presentations. And now we're going to hear another perspective from Greece. We're going to hear from Dora Savili of UNHCR Greece, who will speak about the National Emergency Response Mechanism for unaccompanied children in precarious conditions, which has been established there. Dora.
Thank you very much. Hello from my side also. As I am in the field on a mission in the Aegean Islands, I will stay with you only for a short time, and then my colleague Maria Britsa will take over to share with you some background information for the mechanism. The mechanism has been initiated in January 2021 by UNHCR in support of the Special Secretary for the Protection of Unaccompanied Minors in the Ministry of Migration and Asylum in Greece. And the main aim is the tracing and registration of the hundreds of homeless children and unaccompanied children that we were seeing in the urban settings in Greece back from 2018 until last year. And these children were ending up in protective custody, a measure by the Hellenic police. So they were put in detention so that they are protected in a sense before they are moved, transferred to accommodation, something that was taking even months in the past. So to start with, we would like to share with you a video that we prepared for the promotion of the national mechanism across Greece. Just give me a minute, we'll try to do that. I hope it will work. Can you see that?
Yes, we can. Thank you.
Yeah.
Can you hear it also?
Yes. Yes. Sorry, I think there may be a problem. I think there may be a problem with the sound on the video.
Ως που δημιουργήθηκε ο μηχανισμός ήταν να βοηθήσει να εντοπιστούν άμεσα τα παιδιά που βρίσκονται στα αστεγεία ή σε επισφαλείς συνθήκες διαβίωσης.
So you cannot hear it, right?
Now we hear it. It's fine, but we don't see it anymore. Can you put it back?
Όλα, στη σωματική και ψυχολογική υγεία έχουν περάσει από πολύ δύσκολες καιρικές συνθήκες και συνθήκες υγιεινής, καθώς τα περισσότερα από αυτά έχουν αναγκαστεί να μείνουν για παραταμένα χρονικά διαστήματα σε δάση ή σε καταλημμένα κτίρια ή σε αποθήκες διακινητών μέχρι να αποπληρώσουν το χρέος, με συνέπεια κάποια από αυτά να έχουν εξαναγκαστεί να εμπλακούν και σε παραβατικά δίκτυα. Η μονάδα μας έχει παρουσία καθημερινή στον δρόμο και τις πρωινές και τις απογευματινές ώρες, με άμεσο σκοπό να εντοπίσει τα άστεγα παιδιά. Τα άστεγα παιδιά γενικά μπορεί να εντοπιστούν σε πάρκα, σε εγκαταλειμμένα κτίρια και πάρα πολλές φορές σε καταστήματα ομοεθνών τους, όπου πηγαίνουν να αγοράσουν κάτι. Κυκλοφορούμε έξω στον δρόμο. Μόλις εντοπίσουμε τα παιδιά, ενημερώνουμε για το ποιοι είμαστε και τι υπηρεσίες παρέχουμε. Παρέχουμε ένα ευρύ φάσμα υπηρεσιών που μπορούν να φάνε, να έχουν πρόσβαση στο ίντερνετ, να κάνουν μπάνιο, να πλύνουν τα ρούχα τους και να ξεκινήσει μόλις εκεί να είναι έτοιμα η λήψη ιστορικού. Όταν είμαστε έξω και μας βλέπουν, καταβάλουμε μια πολύ μεγάλη προσπάθεια να τους δείξουμε ότι είμαστε μαζί τους και ότι θα μπορέσουμε να τους παρέχουμε ό,τι είναι δυνατόν για να κάνουμε πιο εύκολη τη ζωή τους. μόλις τοποθετηθεί το παιδί στη δομή επίγουσας φιλοξενίας, αναλαμβάνει μια συγκεκριμένη ομάδα κοινωνικών επιστημόνων και ερμηνέων, ώστε να αξιολογήσει μέσα σε 3 εβδομάδες το βέλτιστο συμφέρον του παιδιού. Παρακαλώ. Η τηλεφωνική γραμμή υποστήριξης της Ειδικής Γραμματείας είναι 24ωρη και καλύπτει όλες τις γλώσσες. Που σημαίνει ότι είναι προσβάσιμη ακόμα και στα ίδια τα παιδιά, αλλά και σε άλλους πολίτες και τοπικές ή δημόσιες αρχές. Έχει αλλάξει ριζικά το έργο μας στον δρόμο, γιατί όπως καταλαβαίνετε, όταν βγαίνουμε έξω και προσεγγίζουμε ένα άστεγο παιδί, για μας είναι πάρα πολύ ευχάριστο κατευθείαν να του λέμε ότι παιδί μου μπορούμε να σε συνοδεύσουμε ακόμα και σήμερα στην δομή επίγουσας φιλοξενίας.
So I don't know if you managed to really follow the video. We have shared the link in case you would like to take some time to absorb the information in chat. And now I give the floor to Maria, who will share with you more information. Thank you so much. Maria will also be in a position to answer to any questions that you may have.
Thank you, Dora.
Hello, everyone, from my side. I hope that you can see the presentation, right?
Yes, we can see it. Thank you.
Great. So, as Dora mentioned, I will provide you a very brief presentation on the National Emergency Response Mechanism for the protection of unaccompanied children in precarious living conditions, which was established in 2021 by the Special Secretary for the Protection of Unaccompanied Children and UNHCR office in Greece as a safety net for the unaccompanied children and to operationalize the abolition of the protective custody. But it is quite useful to go through few information, background information, how everything started and how we have the development of the National Emergency Response Mechanism. So in 2020, UNHCR commissioned a research study for the homeless unaccompanied children, which was conducted by the European Center for Research in Human Rights and Humanitarian Action of the Pantheon University of Social and Political Science of Athens. And according to the findings of this study, almost 63% of the children who had applied for asylum had never stayed in a shelter or an age-appropriate accommodation facility provided for unaccompanied children. Children who were deprived from age-appropriate shelter often ended up in protective custody in the local police stations or pre-removal detention centers until the referral for their transfer to an age-appropriate accommodation facility would take place. Also, in August 2020, UNHCR initiated the implementation of the best interest procedures for the relocation exercise of unaccompanied children under the auspices of the Special Secretary for the Protection of Unaccompanied Minors. And in cooperation with other partners, it was quite interesting the fact that based on on a list by the authorities of the existence of 1,000 unaccompanied children being homeless or living in precarious conditions in Greece, it was managed that only 30% of these children were actually traced and included in the voluntary relocation scheme. Of course, this raised serious questions about the actual location, the living conditions, and the welfare of the 70% of these 1,000 children, which they were not traceable at all at this time. So taking into consideration all these three parameters, meaning the high number of homeless unaccompanied children or unaccompanied children living in precarious conditions, the high number of untraced children, unaccompanied children among this population, which ended up in the high numbers of children being in protective custody, previously being homeless. In December 2020, and following a long-standing advocacy efforts on behalf of UNHCR and of course the child protection actors in Greece, the law of 47/60/2020 entered into force, foreseeing that all unaccompanied minors, third country nationals, or stateless persons should not be placed in protective custody only because they are deprived of safe or unknown residence. In this case, the prosecutor for minors, or failing that, the prosecutor of first instance, acting as the temporary guardian of the children, and the Special Secretariat for the Protection of Unaccompanied Minors of the Ministry of Migration and Asylum should be immediately informed without delay in order to proceed with the rest of the procedures. So all third country nationals or stateless persons who were following the identification were recognized as unaccompanied minors should be referred without a delay to a procedure for finding emergency accommodation through the Special Secretariat and the immediate transfer to safe accommodation should take place. So in light of all this background information and the legislative framework, the Special Secretariat for the Unaccompanied Minors and UNHCR office in Greece envisioned and established the National Emergency Response Mechanism for the unaccompanied children in order to operationalize the abolition of protective custody. Which was the target group for the mechanism? It was all homeless unaccompanied children countrywide, or those children which were living in precarious conditions in the urban settings in Greece. The purpose of the mechanism was the immediate identification and the transfer of these children to safe emergency accommodation structures within 24 hours from the initial tracing and identification. The implementation of the mechanism was supported by UNHCR along with IOM and UNHCR implementing partners, meaning Network for Children's Rights, and ARSIS in Athens and ARSIS in Thessaloniki. So all cases of homeless and unaccompanied children or those living in precarious conditions should be referred to the Special Secretariat and the national mechanism. Which are the main components of the National Emergency Response Mechanisms? First of all the competent state authorities, namely the Public Prosecutor's Office, the police, the Hellenic Police, the Asylum Service, and the Guardians. So the SSPUAM Tracing and Protection Team established is in close collaboration and coordination with the competent state authorities. The second component of the mechanism is the establishment of a 24/7 tracing line, which is used from different services, even NGOs, CP actors, civilians, and also from the children themselves. The third component of the National Emergency Response Mechanism is established teams with info desks and mobile units. The teams are established in Athens, in Thessaloniki, and they're providing the assessment for the best interest of the traced children under the umbrella of the mechanism. They're providing psychosocial support, legal aid, accompaniment where is necessary, and of course, the referral to long-term accommodation and durable solutions. The fourth and last part of the component of the mechanism is the establishment of the emergency accommodation facilities, which are supported by IOM. Currently, are provided 100 places in Attica and in Thessaloniki in order to respond to the urgent needs under the umbrella of NERM. Here is the 24/7 hotline that has been established as part of the National Emergency Response Mechanism under the auspices of the Special Secretariat with the support of UNHCR. The tracing and protection experts team established within the Special Secretariat are the ones handling the hotline, and they're providing support and assistance to all traced homeless children or living in precarious conditions in 24/7. And the interpretation is also, till interpretation services are also provided through the hotline in Arabic, Farsi, Dari, Urdu, Punjabi, Bengali, English, and any other language as per the needs. The referrals to the hotline, the 24/7 hotline, can be made, as we mentioned, by civil society actors, by the Hellenic police, the hospitals, private entities, the refugee communities, municipalities, the asylum service, citizens who may come across in the street of a child being in need for protection and support, and also from the unaccompanied children themselves. In general, every stakeholder or private entity can make referrals to the 24/7 line under the umbrella of NERM. And also, it is important to mention that the hotline is available also via the Viber and WhatsApp. Very quickly, before ending this presentation, it is important also to mention that since the establishment of the mechanism in 2021 and until the May 2022, NERM has received 2,934 referrals of unaccompanied children being in precarious living conditions countrywide. And among them, 1,516 have been provided with protection within 24 hours. And they were placed in age-appropriate care arrangements. It is important also to note that since the Ukrainian crisis and the current Ukrainian situation, NERM has also been assigned as the responsible agency on behalf of the Greek state to respond to the protection of separated and unaccompanied from Ukraine entering Greece. Since April 2022 and until mid-June, 411 separated and unaccompanied children from Ukraine have been benefited by NERM. Thank you very much.
Roisin, you're muted.
Yeah. Sorry. Thank you very much indeed, Maria, to both you and your colleague Dora for this explanation of this very promising initiative. And we're going to move on now to look at the experience in Italy. in particular as regards the hotspots and also quarantine ships. And we're going to hear from Eleonora Salaria from ASGI. Eleonora, apologies for any mispronunciation, from ASGI, who will tell us about the experience there.
No problem. Good morning, everyone. Thanks a lot to ICJ for the invitation. I'm very happy to be here today with you. So I was asked actually to talk a little bit about the hotspot approach and the quarantine ships, and to look at the challenges that it poses to rise of children, especially with regard to detention, but also maybe try to underline some positive aspects of the Italian experience. I will try. Let's see how it goes. Actually, to start from the good side, I have to say that in Italy, there is no lot of widespread debate on alternatives to detention for children, because it's quite clear that children cannot be detained. So there is a general prohibition of detention of children for all unaccompanied minors under Legislative Decree 142 of 2015, and it was mainly due to the Zampa law, the law that was adopted in 2017, that provides a very, let's say, child-friendly approach that put at the center of every discussion the best interest of the children principle, and therefore there was this, for the first time, was clearly stated that unaccompanied minors cannot be detained and they have to be placed in accommodation centers. And this applies to all unaccompanied minors, whether they are asylum seekers or not. As for accompanied children, there is no equal provision, but when they are asylum seeker, all children, they are listed among the so-called vulnerable categories. And for them, detention is prohibited as well. So it's not possible to detain children, families with children when they are asylum seekers. At the same time, it's quite difficult for children to be deported, for families with children to be deported. And the existing detention facilities in Italy are not at all equipped to detain, are not adequate for the detention of families. And so in general, children are not detained. And that also means that the debate on alternatives to detention is not that, is not at the center of debates regarding detention of children. What we have witnessing in Italy is that even though the law is definitely an advanced law in terms of child protection, as it often happens actually in the migration field, there is this very huge gap between what the law says, so the law in the book, and the law in practice. And it is evident, especially at the borders, especially at external borders. And this is exactly where the hotspot approach takes place, and also where the quarantine ships have been, this model has been implemented. And I think the Italian case is quite a good example of this trend. So on the one hand, we witness how border procedures in general, so all procedures taking place at the border, be it asylum procedures, return procedures, even the appointment of guardian or age assessment procedure, when they are implemented at the border, they clash with the respect of children's fundamental rights. And what happens is that the informal procedure implemented at the border, they open up spaces for detention, or in general for coercive measures that can then amount to a de facto detention indeed. On the other hand, we also have seen that in Italy, to have this good legal framework that stresses the importance of the best interest of the child, can be invoked, can be applied by lawyers as well as by other institutional actors, juvenile courts, for example, to put a stop to illegal practice. not to prevent them actually, but to try to end them when they are implemented. So looking at the hotspot approach, it has been clear since 2016 that it would have implied detention of children and detention in very degrading conditions. So we have, let me give you some numbers, between 2016 and 2018, more than 12,000 children have been placed in the 5 hotspots facilities in Italy. And as for the migrants in general, so as for adults, children were to be identified. And so the identification should take place in hotspot. And what happened is that for this initial phase of identification, people in hotspot, they were not free to leave. So they were posed under 24 hours monitoring from the police. They were always under police surveillance, and it was not possible for them to leave the centers before the identification took place. And because of the high numbers of people that stayed in hotspots, hotspots were overcrowded, especially between 2016 and 2018. But then we see that even now there are some moments when there is a situation of overcrowded centers. But because of the high numbers and the fact that the identification procedures took a very long time, minors remain in detention, basically. And an additional element is that also the age assessment procedure and the appointment of the guardian, initially it was supposed to take place while minors stayed in hotspots, and that meant that children spent longer periods as compared to adults in these facilities. And when I talk about long period, I mean weeks, in 2016, 2017, even months. And it basically meant that they were subject to a de facto detention because there was no legal provision. And in theory, the detention of children was prohibited. Of course, they suffered very degrading living and hygienic conditions. And another very crucial and dangerous element is that there was often a promiscuity between children and adults. So they had to sleep, to live with adults, and this exposed them to risk of abuses. In many ways. So what happened starting from 2017, I would say, and then after the adoption of the Zampa law, so the law on accompanied children, there was a mobilization from civil societies, from lawyers, from the ombudsman, for example, the National Ombudsman for the Rights of Detainees, denounced the very bad condition and the fact that children were detained in hotspots. And so several lawyers, they submitted several appeals and Rule 39 in front of the ACTHR. And this mobilization led to, first of all, questioning this unlawful practice, and then to the abolition of detaining and placing children in hotspots for this very long time. So right now the rule is that children are to be identified as soon as possible. The identification take place in hotspots, at ports sometimes even on vessels that rescue people in high seas. But the idea is that the children should not stay in these facilities for a long time, and they have to be immediately moved to accommodation and reception centers, either for asylum seekers, children asylum seeker, or for within the mainstream protection system, general child protection system. And so nowadays there are situations in which children can be found in hotspot, for example, when their age is uncertain and they are identified as adults while they claim to be minors. So it's not always the case that an age assessment procedure is started immediately. So there are these cases, but it's not anymore a widespread practice, a systemic practice, I would say. And something very similar happened with quarantine ships, actually. Once again, the way this model has been implemented shows that a high degree of informality of discretion on part of authorities leads to a violation of children's rights, especially concerning detention. So very briefly, to give you an overview of what happened with quarantine ships, starting from April 2020, based on an administrative act issued by the Civil Protection Directorate, the Italian government has been systematically using these ships to of course, as an infection control and preventive measure. So it was justified by health reasons for migrants to be under quarantine. But the model of boats was also used as a containment measure, as actually on board some preliminary screening were already implemented. So we see this idea of screening, initial screening, and to do this screening at the border in isolated facilities. And there is little doubt that placing migrants on boats, so under police surveillance in a place that they couldn't live in any way. So the only way to leave the boat is actually to jump into the sea and try to reach the port. It has been, I mean, it has been done. People died also in this situation. So it's really detention-like situation, might be justified for health reasons. But what we have seen is that this measure also involved minors between April 2020 and end of October 2020. And the fact that minors had to stay on these boats basically clashed with all the procedures provided for in the law for minors. So there was no proper identification, no appointment of guardians. Minors did not enter into contact with social services, juvenile services. And so basically all the entire procedure that should be followed in case of unaccompanied minors were suspended during this period. And it happened, so minors stayed from my perspective, in my point of view, minors stayed on the ships because everything happened in silence and in this emergency situation in which there was a lot of informality. So the law was not clear. I mean, there was no legal framework, but the procedures were not clear. And so some light was shed on the entire situation only after the death of two teenage boys, one on board and one immediately after his transfer to an hospital. So it took that moment for authorities, again, the Ombudsman for children's rights, the Ombudsman for detainees' rights, juvenile courts, and in general civil society to start a mobilization again, and that eventually to ask that all the procedure, all the guarantees for children, they needed to be applied on ships as well. And this mobilization eventually led the Italian government to stop this practice. So on 20th of October, the Ministry of Interior decided that children shouldn't be placed on ships anymore. Again, as for the same as for the hotspots, there are cases in which children are still held in detention. And very briefly, let me mention that are cases connected to the entire hotspot approach, which is based on discrimination based on nationality. So people coming from certain nationality, certain countries, Tunisia, Morocco, Egypt, and Senegal, they are systematically prevented access to asylum procedure. And we also found that children coming from this country, they are sometimes prevented to access to age assessment procedures. But in general, so what I wanted to underline is that the mobilization in general led to the suspension of these unlawful practices. And let me just, to wrap it up very quickly, the point I wanted to make is that there is a high risk that border procedures in general are implemented in very informal and discretionary ways. This has been defined by some scholars as a rule-by-rule approach instead of a rule-by-law approach. So the rule is the rule of police authorities. It's very discretion application of the law and without, of course, all the guarantees provided for in the law. And this might increase the risk of detention of children as well. We have heard with Carolina, with Maria Giovanna, that one of the features of border procedure is this blurring lines between deprivation of liberty and restriction of freedom of movement. And thinking about that, I think that it can be quite challenging to speak about alternatives to detention at the border, because it's very likely that some measures that are maybe not defined as detention, then they turn into a de facto detention. And so on our perspective as NGOs, what we want to advocate for is the placement of children under the mainstream child protection services and their placement in reception centers within the territory. And this should be like the real alternative to detention, to avoid detention at the borders for children. And I will stop now. I'm available for any questions. And if you're interested, I can put in the chat ASGI report on the situation of migrant children at the borders, also related in which we make some recommendation related to the EU Pact.
Thank you very much, Eleonora. This was really interesting and very, I think, important warning about how measures that aren't meant to be detention can turn into detention without really rigorous safeguards and legal protections against that. And that's a risk that needs to be kept in mind for the negotiations at EU level, and that we would need to be really careful to avoid this. So then for our last presentation, well, just to, first of all, to say, of course, we're running a bit behind time, as you've all realized. We have one more presentation, and then we may just have a couple of minutes for questions. I don't see any so far in the chat, but do feel free to put them there. We're going to just go over time a little bit until 12:30 or so. So thanks for bearing with us, and it's worth staying for our last presentation, which is from Marta Gionco from PICUM, who's going to, I think, bring things back a little bit to the European level and speak about the case for the limited scope of alternatives to detention at the border. So Marta, the floor is yours.
Thank you very much. Thank you also very much to ACJ for inviting me, and also to all the previous speakers for the really interesting presentations. I will try to be brief because I know we are running out of time. I wanted to first start with highlighting some legal safeguards on detention, some of which have already been introduced by the previous speakers. And I will discuss the feasibility of alternative to detention, or ATDs, at borders from a legal and practical perspective. And then I would like to conclude with some comments on whether we actually need detention at all, and whether we can actually foresee migration policies which do not rely on detention. First of all, I think it is clear from the previous presentations that the situations at borders, and also as foreseen in the Pact, would very likely entail detention. As PICUM, we are calling for the end of immigration detention, and we're very clear that we think that detention should never be used for migration enforcement purposes. However, it's also clear that if detention is used at all, there are legal safeguards which need to be implemented. We're not moving in a legal void. We're not asking for something new. We're not calling for new legal standards for now. We're just calling for the respective standards which are clearly there in international law, in regional law, and which have also been clarified by courts. As has already been mentioned by Carolina, detention is arbitrary if it does not follow a clear legal basis in domestic law. And it also has to be implemented after a clearly set procedure. Detention is also arbitrary if it is not necessary and proportional, and this has to be assessed in the individual case. It has to be for the shortest time possible. And for this reason, any legislation which foresees a minimum amount for detention is not legal because it is not based on an individual assessment. And it is also clear that people with vulnerabilities and children should never be detained. It is also clear that it is not relevant from a juridical perspective whether a certain situation is or is not called detention, because the legal safeguards should apply every time the conditions can amount to detention. Maria Giovanna has already mentioned briefly restrictions of freedom of movement. And on this point, I would just like to add that it is clear that there are also legal standards which apply to restriction of movement. In particular, also any restriction of movement should be provided by law. It should serve one of the legitimate purposes, which should be listed by the law. And it should also be necessary for achieving this objective. And I think it's generally very concerning to see that not only different legal proposals, but also the practice of many member states, as it had been highlighted before, seem to be increasingly ignoring these existing standards or trying to sideline them. Moving to alternatives, I think that if we want to look at whether alternatives are feasible at borders, we need to look at it from a legal and from a practical perspective. And from a legal perspective, it is clear that alternatives can be legal only if detention is not arbitrary, which means that if there are no grounds for detention, then we cannot talk about alternatives to detention either. And this is the case for children, as it has been highlighted by Eleonora. In fact, in international law, it's very clear that detention of children is always against the best interest. That children should never be detained for migration purposes. There is a very clear joint general comment by the UN Committee on the Rights of the Child and the UN Migrant Workers Committee. And the European Parliament has also called on 4 different occasions for the end of immigration detention. Maria Giovanna also mentioned the position of the European Parliament in previous negotiations. And I think for all these reasons, it is clear that we cannot really talk about ATDs at borders either, because detention of children is not legal, full stop. The same should also apply to people in situations of vulnerabilities. I'm going to put the link to a report we have published last year, in which we collected different bodies from international law and also different soft law instruments which look at different groups of people with vulnerabilities. And it is clear from an analysis of international law that detention of people with vulnerabilities is illegal, it's arbitrary. For this reason, we cannot really put people with vulnerabilities in ATDs at borders either, also because the special needs cannot actually be met at borders. For other groups of people, we can consider alternatives. Actually, there is an obligation to consider alternatives only after it has been established that there is a legal ground for detention in the specific case, which means that, for instance, if there is no risk of absconding, there cannot be any alternatives to detention either, because there is no legal ground for detention. But if such a legal ground for detention exists, then states have an obligation to assess whether alternatives can be applied. As mentioned by Alexander, it's also important to underline that if there is no reasonable prospect of removal, then detention is also unlawful, and then therefore ATDs can also not apply. After we assess that there is a specific ground for detention and detention would not be arbitrary in that circumstance, states have an obligation to assess alternatives. And then we move to looking at the practical perspective, meaning how can alternatives be feasible and what alternatives can we consider at borders. There are 2 main types of alternatives. Some are enforcement-based. For instance, we talk about reporting, we talk about bail, we talk about surrender of documents. All of these do not really support people with the work on migration procedures, but just basically apply the same logic, which is the logic behind detention. The second type of alternatives are engagement-based alternatives, which are proven to be more humane and more effective. And a type of engagement-based alternatives is the use of case management, which is a social work approach to migration. This model has been implemented by several NGOs across the European Union. The evidence has been collected also through the European ATD network. I think some of the members of this network are also in the call today. And the use of this model has been proven to be much more effective and really helping people in working on resolving their case. But for case management to be successful, there are certain preconditions. First of all, people have to be allowed to live in the community, because it is a community-based solution. So living in a community is really a key element. People need to be able to meet their basic needs, which means that they need to be able to access integrated support services. And thirdly, people need time because they need to develop a relationship of trust with the case manager. They need time to consider all the different options available to them. And they need time to actually work on resolving their migration case. And it is clear that all of these preconditions cannot be fulfilled at borders. And for this reason, we think that if we want to have meaningful alternatives, these have to have like on the territory as well. The second point I would like to mention today, and this is maybe zooming out a bit from the discussions that we had until now, is that when we're discussing all these legislative proposals and generally when migration policies in the EU, we often seem to be considering a choice between arbitrary detention and detention with some legal safeguards, basically upholding the standards which exist now, which are not implemented but which exist, and detention which is completely arbitrary and de facto. But we have to always keep in mind that these are not the two only options. In fact, immigration detention is not a necessary evil that we have to deal with, but it is something that has been put in place by very specific policies. As mentioned before, it has also very deep roots with racist systems, with systems which are based on nationalities, with systems which enforce colonial ties. And for all these reasons, we can dismantle the system and we can think of different ways to foresee migration policies which do not rely on detention. It is clear, I'm not going to go into all the resources on why detention is always harmful, detention is always disproportionate, and it's also clear that detention is ineffective. This was also clearly specified by the Special Rapporteur on the rights of migrants. At the global level, NGOs have been increasingly calling for working towards the end of immigration detention. And from a recent report of the International Detention Coalition, there are also some interesting examples of states which do not rely on detention. For instance, in Ecuador, all immigration detention centers were closed in January 2017. In Uruguay, there are no detention centers either. And we all know that during the first wave of the pandemic in Spain, all the detention centers have been closed for a certain amount of months. And we know that the system did not collapse because suddenly we did not have detention centers. I would rather say the opposite happened. And just to conclude maybe with some words of hope, I think for all these reasons, we really have collectively to also think about how can we build migration policies which do not rely on detention, and how can we continue advocating for that too. Thanks again, and I'm happy to reply to any questions.
Thank you very much indeed for these very helpful concluding presentation. I see that there's been some good discussion in the chat. There have been some questions. I think most of those questions have been answered, but at least there was a question by Andrea Contenta regarding the Greek experience about shipwrecks last year in which children were detained under COVID-19 measures, but this has been, I think, answered. There was also a question by Carolina about regarding Greece, about the situation at the border and if it applies to mainly children in the streets. But also she says that there are children detained upon arrival in the closed facilities at the border. And that these are not exempted from the facilities. And I think this has also been answered by Alexandros, saying that the mechanism is applicable to UAMs across the country. I also saw that there was a question which I think hasn't been answered from Isabella Matcher regarding a question to Alexandros as to the status of the new closed facilities, when will they open and on which islands? So just open the floor to any of the speakers who would like to add anything further in answer to these questions or others that I may have missed. There's also some very helpful links being put in the chat for different materials, which are worth looking at. All right, so I don't see any of the speakers who wish to take the floor, and I thank you to all the speakers who put answers in the chat already. So I hope that's that answers at least most of the questions that have been put. So I think we'll conclude here. We are already a little bit over time, but I think it's been worth continuing. I'd just like to thank all of the presenters and those who've engaged in the chat, and thank you to everyone who's come to hear these presentations. It's obviously, and I think the point that comes from all of the discussion today is how complex this is in practice, and how much this means we need really effective safeguards in EU law and in the proposals in the new pact. That it's not enough just not to provide for detention, but that there really has to be safeguards to prevent it. That detention can happen in practice under proposals that don't explicitly provide for that, and that you need really careful safeguards to protect children in extremely vulnerable positions. And we have seen some also positive examples of good practice in that regard. So for ICJ, and I'm sure many of the others here on the call, we're going to be following up very closely on the proposals for the EU Pact as much as we can to raise awareness of the real human rights concerns in light of the practical experience in the member states, the concerns that there are about the potential for human rights violations, including relating to detention. We're planning another webinar along the same lines as this in the autumn, so please keep an eye out for that. We'll keep you posted about, I think the topic hasn't been finally decided, but we'll keep you posted about that. And just to let you know that we've also published training materials on alternatives to detention of children. And we have a case law database on the same subject, which we'll share with all of you, and hopefully these can be helpful resources. So thank you all very much for coming, and we hope to keep in touch.